The envelopes arrived on a Tuesday. Not by email. Not posted on the community website. Physical envelopes, thick, cream-colored, stamped with the bold insignia of the HOA. By 4 p.m., nearly every mailbox in Brookstone Ridge had been opened, and nearly every household was staring at the same number. Effective immediately. Monthly dues will increase from $250 to $1,000. No warning. No vote. No discussion. Just a single-page notice titled, Emergency Infrastructure Assessment Funding Adjustment. Maria Alvarez was the first to call her neighbor. She was retired, living on a fixed income, and had chosen Brookstone Ridge because the dues were stable and predictable. Her hands shook as she reread the letter. A 300% increase wasn't an adjustment, it was a financial earthquake. Across the street, Daniel Kim stared at the same page while doing the math in his head. That was an extra $9,000 a year. For what? The sidewalks looked fine. The pool had just been resurfaced last summer. Landscaping hadn't changed. By dinnertime, porch lights flicked on earlier than usual. Neighbors drifted outside holding identical envelopes. Conversations overlapped. Did you get this too? This has to be a mistake. They can't do this without a vote, right? By 7:30 p.m., someone had created a private neighborhood group chat. Within minutes, screenshots of the letter flooded the thread. Anger replaced confusion. The HOA president, Richard Halvorson, had signed the notice himself. No mention of a board vote count. No financial breakdown. Just one vague paragraph about urgent structural integrity concerns and time-sensitive vendor commitments. Vendor commitments. That phrase stuck. At 8:12 p.m., Daniel posted something that shifted the mood entirely. He had attached a screenshot from the HOA's online portal, the newly uploaded Infrastructure Reserve Report. It was 47 pages long. Dense. Technical. Easy to ignore. But one line item stood out. Exterior Structural Rehabilitation Contract, $2.4 million. No prior announcement. No community meeting minutes referencing it. And the selected contractor? Halvorson Property Solutions, LLC. Maria stared at her phone. Is that? She typed. Another neighbor responded within seconds. Same last name. Silence fell across the chat. It could be coincidence. Halvorson wasn't the most common name, but it wasn't impossible either. Still, something about the timing felt off. The LLC had no website. No online reviews. No visible history of work in the county. Daniel dug deeper. Public Business Registry records showed Halvorson Property Solutions had been formed just 3 months ago. 3 months. And now it had secured a $2.4 million contract, funded by a 300% emergency dues hike. At 9:05 p.m., someone rang Maria's doorbell. It was Thomas Reed, a quiet accountant who rarely attended HOA meetings. I've been reviewing the reserve report, he said, holding printed pages marked in red pen. There's no engineering certification attached. No independent inspection summary. And no competitive bid documentation. Maria felt her stomach drop. They're supposed to get at least 3 bids, Thomas continued. That's standard governance. Outside, more residents were gathering in the street under the glow of porch lights. The mood had changed. This wasn't just frustration anymore. It was suspicion. At 9:40 p.m., another message appeared in the group chat. HOA office closed until further notice. No explanation. Moments later, Richard Halvorson himself posted in the official community portal. Failure to remit updated dues within 30 days will result in liens as permitted by association bylaws. That was the moment fear turned into resolve. Maria looked around at her neighbors standing together on the quiet suburban street. Elderly couples. Young families. People who had never organized anything more dramatic than a block party. They think we'll just pay it, Daniel said quietly. Thomas adjusted his glasses. Not if the numbers don't add up. Across the neighborhood, lights stayed on later than usual. And somewhere inside a locked HOA office, a newly formed LLC sat at the center of a $2.4 million question. By Wednesday morning, Brookstone Ridge felt different. No one waved casually at the mailboxes. Conversations were shorter, sharper. Phones buzzed non-stop. The private group chat had exploded overnight. 146 unread messages by 7 a.m. screenshots, links, highlighted PDFs. What started as shock was turning into investigation. Thomas Reed didn't go into his accounting office that day. Instead, he sat at his dining table with a laptop, a calculator, and 3 years of HOA financial statements pulled from the community portal before access mysteriously became temporarily restricted. He moved slowly, methodically, the way he did during tax audits. "Something's wrong," he finally posted at 10:13 a.m. The reserve fund, the savings account meant for long-term repairs, had been healthy. In fact, last year's annual summary boasted a surplus. There was no documented emergency, no structural failure notice, no engineering red flag. Yet suddenly, there was a $2.4 million urgent rehabilitation contract requiring immediate funding. Daniel chimed in. He had searched county permit records. "There are no filed permits for major structural work," he wrote. "None. Not for this neighborhood." Maria read the thread twice, her heart pounding harder each time. By noon, residents began connecting dots. The contract amount, $2.4 million, was almost identical to the projected revenue from the 300% dues increase over the next 24 months. It wasn't a temporary spike. It was designed to sustain something. Or someone. Then came the post that shifted everything. A neighbor named Aisha, who worked in commercial procurement, uploaded screenshots of the LLC registration for Halvorson Property Solutions. Registered address? A small commercial suite downtown. Daniel zoomed in on the document. "That's the same address listed for the HOA's legal office," he typed. Silence. Not illegal by itself, but uncomfortable. Aisha kept digging. She searched state contractor licensing databases. "No active contractor license under that company name," she wrote. Thomas leaned back in his chair, staring at the ceiling. If the company wasn't licensed for large-scale structural rehabilitation, how had it been awarded a multimillion-dollar contract? At 3:42 p.m., an email blast went out from the HOA board. Subject line: clarification regarding infrastructure improvements. The message was brief, defensive. It cited confidential engineering assessments and warned residents against spreading misinformation that could harm property values. It did not address the lack of competitive bids. It did not explain the newly formed LLC. And it did not provide documentation. Instead, it closed with a reminder. Delinquent accounts will be subject to lien proceedings without exception. Maria felt something shift inside her when she read that line. It wasn't just about money anymore. It was about intimidation. By early evening, the group chat had grown into something organized. A shared folder was created. Financial statements were uploaded. Screenshots archived. Public records bookmarked. Neighbors who had barely spoken before were now collaborating like a task force. Thomas posted a spreadsheet comparing projected repair costs for similar communities in the county. None exceeded $900,000, and those included full roof replacements and road resurfacing. Even at high-end pricing, he wrote, $2.4 million doesn't align with the visible scope of work. That was when Daniel made the call that escalated everything. He contacted a local investigative reporter. Not to accuse. Not yet. Just to ask a question. What happens when an HOA awards a multimillion-dollar contract to a company formed 3 months ago with no license and no visible history? The reporter didn't hang up. At 9:17 p.m., another update appeared in the HOA portal. Emergency board meeting scheduled. Closed session. No resident attendance permitted. The timing wasn't subtle. Maria stepped outside onto her porch again. The streetlights cast long shadows across identical driveways. But this time, the neighborhood didn't feel passive. It felt awake. Inside one house, a spreadsheet was being refined. Inside another, public records were being downloaded. And somewhere behind a closed boardroom door, someone had realized the residents weren't just angry anymore. They were prepared. The emergency board meeting lasted exactly 43 minutes. Residents weren't allowed inside, but they watched board members arrive. 3 cars. Then 4. Then Richard Halvorson's black SUV pulling into the clubhouse parking lot 10 minutes late. The blinds were drawn before sunset. By the time the doors reopened, no one was smiling. Within an hour, the HOA portal updated again. Due to ongoing misinformation campaigns, the board has retained external legal counsel. Any defamatory statements directed at board members or affiliated vendors will result in legal action. Affiliated vendors. Daniel reread that phrase 3 times. It wasn't denial. It was distance without separation. Then Thomas received the email that cracked everything open. The investigative reporter Daniel had responded with a single attachment, a property lease filing for the downtown commercial suite listed under Halvorson Property Solutions. The lease guarantor wasn't the LLC. It was Richard Halvorson, personally. Maria stared at the document on Thomas's tablet as they stood in her kitchen that evening. So he didn't just sign the HOA contract, she said slowly. He backed the company financially. Thomas nodded. Which means if the company profits, he profits. Conflict of interest wasn't a rumor anymore. It was documented. But the deeper problem wasn't just ownership, it was process. Aisha had uncovered another detail buried in last year's meeting minutes. A clause in the bylaws required any capital expenditure exceeding $500,000 to be approved by a majority homeowner vote unless tied to a declared structural emergency certified by an independent engineer. There was no certification attached to the reserve report. No engineer's stamp. No public disclosure. And now, public business records showed Halvorson Property Solutions had amended its filing 2 weeks ago, expanding its business purpose to include residential structural rehabilitation and exterior construction. 2 weeks ago, after the contract had already been referenced in internal HOA documents. Thomas leaned back in his chair that night, exhaustion lining his face. This wasn't rushed because of an emergency, he said quietly. It was rushed so no one would notice the sequence. Across the neighborhood, word spread fast. The group chat wasn't chaotic anymore. It was strategic. Residents began compiling a timeline, LLC formation date, lease signature, reserve report upload, dues increase notice, portal lockdown. Each event stacked on top of the other like evidence waiting to be presented. And then, just before midnight, another bomb dropped. The HOA treasurer resigned. No explanation. No farewell message. Just a brief notice posted to the portal. Treasurer position vacated effective immediately. Maria felt the air leave her lungs when she read it. Treasurers don't leave in the middle of multimillion-dollar infrastructure projects. Not without a reason. Daniel called Thomas within minutes. That's not random, Daniel said. That's pressure. By morning, residents were no longer asking whether something was wrong. They were asking how deep it went. At 10 a.m., certified letters began arriving at several homes, including Maria's. Formal notice of delinquency for failure to remit updated dues. The increase hadn't even hit its 30-day deadline. It was intimidation, plain and simple. Maria folded the letter carefully and placed it on her kitchen table next to the printed lease agreement with Richard Halvorson's signature. For the first time since the envelopes had arrived, she didn't feel afraid. She felt focused. They think liens will scare us, she said when neighbors gathered that evening. But if they file one without legal authority, that's another violation. Thomas adjusted his glasses again, the quiet signal that he was already thinking 3 steps ahead. They've escalated, he said. Which means they know the paperwork won't survive scrutiny. The residents stood together under the glow of porch lights once more, but this time with documents in hand, timelines mapped, and resolve solidified. Because what had started as a 300% dues hike was no longer about fees. It was about misuse of power. And somewhere inside a locked HOA office, a president who had counted on silence was realizing something dangerous. The residents weren't backing down. They were preparing to fight. The courthouse steps felt colder than Maria expected. It wasn't the weather, it was the weight of what they were about to do. 23 homeowners stood together outside the county civil courthouse, each having contributed to a shared legal fund. Some had never been inside a courtroom before. But they weren't there for drama. They were there for answers. The filing was precise. Motion for injunctive relief to halt the 300% dues increase, request for financial disclosure, and petition for an independent forensic audit of the association's accounts. Thomas had worked closely with the attorney they retained, a calm, methodical litigator who specialized in community association disputes. Inside, Richard Halvorson sat at the defense table beside the HOA's newly hired counsel. He looked composed, but the tightness in his jaw betrayed him. The judge wasted no time. "Counsel," she began, peering over her glasses, "explain to me how a 300% increase was enacted without a homeowner vote." The HOA attorney stood. He spoke about urgent structural concerns, deferred maintenance, fiduciary duty. He referenced confidential engineering advisories that justified immediate action. The judge flipped through the submitted exhibits. "I see no stamped engineering certification attached," she said flatly. "Where is it?" A pause. "We can provide supplementary documentation." "You should have provided it already." Silence filled the room. Then the resident's attorney approached the podium. Direct. No theatrics. Your Honor, in addition to the lack of certified emergency documentation, we have submitted public records demonstrating that the contracted vendor, Halvorson Property Solutions, LLC, was formed 3 months ago. The lease guarantor is the HOA president personally. Furthermore, no competitive bidding process was documented. The judge looked up slowly. "Is that accurate?" The HOA attorney shifted in place. "The vendor is properly registered." "That wasn't my question." Another pause. Richard Halvorson leaned toward his lawyer, whispering sharply. Maria could feel her heartbeat in her ears. The resident's attorney continued. "We are not alleging criminal conduct at this time. We are asking the court to prevent potentially improper financial transfers until transparency is established. Once funds are disbursed, they cannot easily be recovered." That line landed. The judge tapped her pen twice against the bench. "Has any money been transferred to this LLC?" The HOA attorney hesitated, just a fraction too long. "A preliminary mobilization payment has been issued." "How much?" $400,000. A murmur rippled through the gallery. The judge's expression hardened. "Without a homeowner vote, without certified emergency documentation, and without competitive bids." The attorney did not answer directly. Thomas sat rigid in his seat. Maria gripped the edge of the bench. This was the moment. The judge leaned back. "I am issuing a temporary injunction effective immediately," she said. "No further funds are to be transferred pending review. Additionally, I am ordering a court-supervised forensic audit of the association's financial records for the past 3 fiscal years." The words echoed. Court-supervised. Forensic audit. Richard Halvorson's composure cracked for the first time. He leaned back in his chair, color draining from his face. "And one more thing," the judge added. "If the audit reveals breaches of fiduciary duty, this court will not hesitate to refer the matter for further investigation." Maria exhaled slowly. Outside the courthouse, residents didn't cheer. They didn't celebrate. They stood together quietly, absorbing what had just happened. This wasn't victory. Not yet. It was exposure. $400,000 had already moved. Bank statements would now be examined line by line. Email communications subpoenaed. Meeting minutes dissected. And for the first time since the envelopes arrived, the power dynamic had shifted. The HOA board was no longer in control of the narrative. The court was. As Maria looked back at the courthouse doors, she realized something profound. They had walked in as worried homeowners. They had walked out as plaintiffs in a case that was about to unravel far more than a dues increase. And somewhere behind closed doors, a forensic auditor was preparing to open books that someone had hoped would never be read. The forensic audit took 6 weeks. 6 long weeks of sealed boxes, encrypted files, subpoenaed emails, and bank statements pulled directly from the association's financial institution. Residents went back to their routines, work, school drop-offs, quiet evenings, but nothing felt normal. Every porch conversation ended the same way. "Have you heard anything?" When the preliminary audit summary was finally filed with the court, it wasn't dramatic. It wasn't emotional. It was clinical. And that made it devastating. The report confirmed that $400,000 had been transferred to Halvorson Property Solutions as a mobilization payment before any visible work began. No engineering emergency certification existed in HOA records. No competitive bids were documented. Email correspondence revealed that contract drafts had been exchanged before the board formally referenced an urgent infrastructure concern. But the most damaging detail was buried on page 19. The LLC's operating agreement listed Richard Halvorson as its sole managing member. There was no ambiguity left. When the final hearing resumed, the courtroom was fuller than before. Residents filled nearly every bench. Richard Halvorson no longer looked composed. The confidence that once carried him through board meetings had evaporated. The judge didn't raise her voice. "Mr. Halvorson," she said evenly, "you were entrusted with fiduciary responsibility over this community's funds. Instead, you approved a 300% dues increase without a homeowner vote and directed association money to a company you personally controlled." His attorney attempted to argue that the project would have benefited property values long-term, that there was no malicious intent, that the funds were recoverable. The judge stopped him. "Intent does not erase conflict of interest." She turned a page. "Effective immediately, the dues increase is void. The association is ordered to reverse any penalties or lien notices issued under that increase. The $400,000 transfer is to be frozen pending recovery proceedings. Furthermore, this court orders the removal of the current board officers subject to an emergency community election supervised by a neutral third party." A quiet gasp moved through the room. Then came the line no one expected. "This matter is being referred to the appropriate authorities for review of potential breaches of fiduciary duty and financial misconduct." Maria felt tears press behind her eyes, not from triumph, but from relief. Outside the courthouse, residents finally allowed themselves to breathe. There were no victory chants, no gloating. Just exhausted smiles and steady handshakes. Within a month, a special election was held. Thomas was nominated but declined. Instead, a small slate of residents committed to transparency, open meetings, and quarterly financial disclosures stepped forward. The first act of the new board was simple. They published every financial document online. Every contract. Every reserve report. Every line item. And for the first time since the envelopes arrived, Brookstone Ridge felt like a neighborhood again, not a battlefield. Maria stood on her porch one evening watching children ride their bikes down the same street where neighbors had once gathered in fear. The lights were warm. Conversations were casual again. But something had changed permanently. The residents understood their bylaws now. They understood voting thresholds, audit rights, fiduciary duty. They understood power. The 300% dues hike had been designed to move fast, to overwhelm, intimidate, and collect before questions formed. Instead, it had awakened an entire community. Because in the end, it wasn't just about money. It was about accountability. And when ordinary homeowners decided to read the fine print, organize quietly, and stand together, even a board that thought it was untouchable discovered something powerful. Transparency isn't optional. It's enforceable.